Now for example, then the other category like inventions. If you are inventing something, inventions, designs, technology will come under the second category. Now if the creator is inventing something, if any invention is made in the form of any product or a process, then he will be given an IPR, what is called as patent. Patent. So patent is an IPR. Because of an IPR, it is having the patent, it is given, it is an exclusive right given for the inventor, for his invention, for his or her invention. So patent is an IPR given for invention, given for invention. If you invent something, then you can apply for patent. I told you. And then the other part, like there is something like concept called industrial design. Industrial design, that is again a part of, we can put under this category. Patent for inventions, it is patent. Then industrial design, that is again industrial design is also part of IPR. And third one, it is trade secret. Trade secret. Trade secrets. So this classification, what is that? Patent, industrial design and trade secrets. So all these constitute the different types of intellectual property. We'll deal one by one regarding patent. See, industrial design and trade secret are not that important, but just have an idea what's an industrial design and what is this trade secret. We'll discuss that. But for you, the most important intellectual property right is patent. Patent. Try to understand that. So patent is an intellectual property, right? Patent is an intellectual property right given for inventions. Now regarding patent, the most important thing you need to have the protective period for patent under WTO TRIPS agreement is 20 year. 20 year. This is very, very, very important. The patent is protected for 20 years. Patent is protected for 20 years. After 20 years, anybody can use that invention. It will become off patent. Now be very clear regarding the patent intellectual property rights. Regarding patent, try to understand that as per the TRIPS agreement, we already discussed yesterday. I am repeating again that it was every member country were asked to shift from process patent to product patent. So before going to that process patent and the product patent, we will have an idea about the history of patent laws in India. That's very important. India's history means laws, patent laws. How Indian patent laws have functioned and what is the present situation in case of India. Now regarding way back in 1911, British government have passed a patent law. British government have passed a patent law. In 1911, British government have passed a patent law. And what was the specialty of this patent law is that it was basically this law, like what the Britishers have done in relation to other policies. The patent law created or means implemented or passed by the British government, it was basically to support the British companies. It was not helping the common man. So it has this law have resulted in huge profit being made by basically the British company during the British period, and it continued. So all the patent holder used to charge exorbitant rate for their inventions, and this continued mainly for almost all the product. So to bring change, so what happened is that during this time it was product patent. During this time from 1911 the British, patent was mainly for product patent. Process patent was not entertained during this period. But in 1970, it's very, very, very important. In 1970, the Indian government have passed an act, what is called as Indian Patent Act. Indian Patent Act was passed in 1970. In this law, we started providing process patent also. Along with product patent, we allowed process patent mainly to drugs and food items. So we allowed process patent. Now what is, so product patent, so from 1970 onwards, there exists both process patent and product patent. Now since, so from 1970 onwards, because of process patent, many people started using different processes. They started producing items and get it patented, and because of process patent, because of competition, what actually result is that there were lesser prices for many of the drugs being produced. So in India, when we talk about patent, basically this process patent have helped our pharmaceutical industry to produce, using process patent, to produce cheaper drugs. Now from 1970, in the next 20 years, India have captured the drug market, especially in relation to generic drugs. I'll discuss what is this generic drugs. Very simple. Any drug, any patented drug, I told you this patented drug is having a right, the patent owner have right for a period of 20 years. After 20 years, this right is not there. Anybody can produce. If I am a patent holder of a drug, I have this right only for 20 years. In the 21st year or after the next day of completion of this 20 year, you can also produce my drug. You can also produce my drug. It means that then that drug have become, after patent, that drug have become generic drug. So what is a generic drug? Drug is same, quality is same, everything is same. Now that drug have become generic. Anybody can produce, nobody can stop you from producing that drug. So a patented drug, after the time, protected time, that is after 20 years, that drug will become generic drug. Now, when a drug becomes generic, you can produce that drug, you can produce this drug, you can also produce that drug. What will happen to the price of that drug? It becomes cheaper. It becomes very cheaper. And because of this process patent, and it became one of the largest market for generic drug, not only for the Indian market but also for the outside global. The Indian generic pharmaceutical companies, we have that edge in the case of generic drugs. We almost captured, even to US also we are providing generic drugs. Okay, US market also we have captured, because see there also it's in everywhere the ideology is very simple. Good product at a cheaper price, we will purchase that only. It's not that who is producing, it's not a matter there. Now be very clear with this term, so we'll come to it. Now process patent have helped in the growth of Indian pharmaceutical industry, and we in the next 20 years, India have become the major production house of major generic drugs. But so this was a good thing for India, but in 1995, India joined WTO. India joined WTO in 1995. Not only India, every member country joined WTO. So once we joined the WTO, we had an obligation under a multilateral agreement of WTO, what is called as TRIPS. So under TRIPS is a multilateral agreement of WTO dealing with intellectual property rights. TRIPS means trade related intellectual property rights. Trade related intellectual property rights. So under the TRIPS agreement, it was obligatory for all the member countries within a certain period of time. So it is, be very clear, yesterday when we discussed agreement on agriculture, it was clearly said that a special and differential treatment is given for developing country, so and for least developed country it was no obligation. But in the case of TRIPS agreement, LDCs also have to commit to it, but with a special and differential treatment. So in the case of developed country have to implement TRIPS agreement within a year. For developing country, initially 5 years were given. 5 years were given initially, and then if there is any situation, if it is required, it can be extended for 5 more years for developing country to follow TRIPS agreement. And for developing country, initially it was given 11 years, and lot of times it were extended. In the case of LDC. It is there in the material, please go and read it. Now, so India is a developing country. So normal year is given 5 years and a 5 year extension is given. So within 10 years, India have to move from process patent to product patent, mainly in drugs and foodstuff. So since we have to, to bring this changes, to move from process patent to product patent under the TRIPS agreement, in 2005 we amended our patented law to shift to product patent. So when we shift to product patent, we need to protect the interest of the common man. So many parallel laws were made. You might be knowing that we have drug price control order where essential medicines will not come under any laws or any agreements. Now again, along with that, to protect the patented drugs from higher price, there we introduced so many other changes. Like we introduced a very important section which is very, very important under this amendment. So under 2005 amendment, when we shifted to product patent under TRIPS agreement, we introduced a very important section, very important section, what is called as Section 3D. Section 3D of Indian Patent Act is very important for you. We'll see it because it is one of the issues. It is one of the issues related with intellectual property rights. Your mains already UPSC asked a mains question from Section 3D. Now you need to understand what this Section 3D is all about. Now why this section have been introduced by the Indian government in the Indian Patent Act. Now I'll tell you what this multinational, especially the drug companies, what they have done. Normally it's very simple. Okay, these people have only one thing in their mind, profit. These pharmaceutical companies have only one thing in their mind, to make profit. Now what they do is after when a drug's tenure comes to an end under patent protection, that is in the 18th or 19th or 20th year, they themselves will appoint a research team and they will come up with a report by saying that this drug efficiency have gone. What drug? This efficiency have gone. Now even if you take this medicine, your disease will not be cured. Then they will say that, okay, our team have come with a new drug which can cure the present disease. The old drug is now have become less efficient. We have produced a new drug, and then what they will do? They will apply for a patent, new patent, and they can extend the patent for another 20 more years. This is what is called as evergraining of patent. Patent becoming evergreen means, so normally patent tenure is for 20 years. Now by using this strategy, by saying that this drug, we have reinvented a drug which is having better enhanced efficiency, they will claim a new patent, and that patent will be again extended for 20 years. So normally pharma multinational company continue this process in many of the cases, and this concept is what is called as, this term is very important, evergraining of patent. Now you tell me, why the government have inserted Section 3D? To prevent evergraining. And what the Section 3D have explained is that, what it has introduced is that, it said that to get patent to an already extended patent, if you want to patent to extend it, you need to prove that the drug is having enhanced efficiency. Enhanced. So this word is used in the section 3D. What is called as enhanced efficiency. Enhanced efficiency. And this section have not explained what is this. The section have not explained what is, it has not defined what is this enhanced efficiency. Now, in a very important case, now a company, pharmaceutical company, Novartis, for their drug, drug called Glivec, Novartis, what they have done is, for this drug, Glivec drug, they said that they applied for a new patent by saying that we have this drug, this Glivec drug is now having a better efficiency, so many features, this drug is having so many new features, and they applied for the patent. Indian Patent Office have rejected it. Glivec, Novartis application for Glivec patenting that drug. Novartis approached the Supreme Court. Supreme Court, in its very famous judgment, in the Novartis case, came with a very famous judgment, and it said that, and Supreme Court have given the definition for enhanced efficiency. In its Novartis case, it said that the enhanced efficiency here means therapeutic efficiency. Enhanced efficiency here means therapeutic efficiency, and it has to be proved, and the medicine which, if there is any minor improvement for the existing drug, that will not be considered as therapeutic efficiency, and the Supreme Court have rejected the Novartis case, and now Glivec is not having patent in India. Now because of that, this judgment have become very important. So this Novartis case judgment, what it has done is that it has given a clear definition for section 3D. What do you mean by enhanced efficiency? What is that? It is therapeutic efficiency. And because of this judgment, what it has done for the entire pharmaceutical industry in India is that now no company will come with minor improvement and will go for evergraining of their patent. So it's a very important judgment in the case of intellectual property regime in India. And regarding this section 3D, US is against this section 3D. Why? Many of these multinational companies are from US. Now US says that India is having a very poor intellectual property regime. They don't follow the TRIPS agreement in true spirit, but actually the TRIPS agreement says that section 3. So section 3D is not against TRIPS agreement, it is provided. So US can't go to WTO under TRIPS agreement and take India for legal dispute, because we are done it under the TRIPS agreement itself. But then if the US can't take India to WTO, then US have its own style of dealing with the country which they don't like. What the US will say? Follow us, oblige us, otherwise we'll put you, what is that normal thing what they do? Sanctions. International sanction. US sanction. US sanction means equivalent to international sanctions. But actually US will not do it. It's only just creating a fear. It's only just because US have other interest over India. But what US have done is, US have put India under priority watch list country. So it's a term used under the term, the US will put certain countries under priority watch list. Means they are now, it's like a lowest grade. If you go beyond that list, then sanctions can be made. So US is there in the priority watch list. Why? Reason is India is having a poor IPR regime, and one of the reason for this poor IPR regime is section 3D. Go and read that material. In the material, section 3D is the most important from your mains point of view. It's there in the material. So be very clear with this section 3D. What actually section 3D tried to do? It prevent evergraining of patent, and it has helped India, not only India and also other developing countries. Now the problem is with the US is that by following India, many other developing countries like Brazil started implementing their own Section 3D. Okay, that's a different case. Okay, so be very clear with that. And this was the question UPSC asked in 2013. In 2013, see the third mains question. Bring out the circumstances in 2005 which forced amendment to the Section 3D in Indian Patent Law 1970. Just pause there. What is the reason for why in 2005 Section 3D was inserted or it was amended and this provision were added? Because we have to shift to product patent under the TRIPS agreement. So we need to protect our own interest. We need to protect evergreening of patent. That's why we have made amendment to Section 3D of Indian Patent Act. Then answer the second part. Discuss how it has been utilized by the Supreme Court in its judgment in rejecting Navarati's patent application for Gleevec. You have to explain, it's there in the material, you have to explain. Then discuss briefly the pros and cons of this decision. Pros are advantages. Advantages, the major advantages I told you, it can, see what will happen is by providing protection or by ensuring evergreening, it will result that many of the drugs will become affordable. And the India being a generic drug producer, not only affordable, we can not only produce for India, we can also produce the same drug for other countries also, especially poor countries like in Africa like that. And it can also prevent other to follow. It can also prevent this monopolistic tendencies of other companies who are going to use this provisions like using Section 3D. Now what are the cons? Cons is from the US side. The US, especially many of the multinational companies are controlled by US and Western European country. They will say that, okay, because see, India is one of the first country to introduce this section in their respective IP laws. So we may be put under, already we have been put under this priority watch list country, and if India if uses these provisions more, see, try to understand that even though this section is there, we have used this section very rarely. We have not used it for many of the cases. We have used this section, or the Indian Patent Office have rejected this evergreening of patent in very few cases only. Now if Indian government has started using it in more cases, or Indian Patent Office is using in many of the cases, in drug cases, now if you can see that in the coming few years, many of the drugs patent is going to end. In 2017, 18 and 19, you can see many drugs will become off patent. Now once it become an off patent, now try to understand that that's why now US multinational companies have a very simple way of dealing things. What they are trying to do? They are started acquiring Indian generic pharma companies. Now many multinational companies have come here, they are using misusing FDI provisions, 100% FDI in pharmaceutical companies. They are coming, acquiring it, and then once they are acquired it, so that's a different issue over there, but just have an idea. It was this question I asked mainly because of this current affair, especially the judgment, Supreme Court judgment in the case of Navarati's case. Now be clear, in this question it is having three parts. You need to address three parts. First part is why this Section 3D was or amended in 2005. Second is the Supreme Court judgment. Third is the pros and cons and a conclusion. So you have to, in 200 words, you have to address all these things. Everything is there in the material I had given. You just go and read that material on Section 3D. So this is one of the major issues related with intellectual property rights in India. So it's necessary that you need to be very clear what this Section 3D all about. Very simple, it prevents evergreening of patent.